Hello, everyone, and welcome to yet another session on polity and constitution. I hope I'm audible as well as visible. Good evening, everyone. We'll wait for others to join and then we'll begin our discussion for the day. Okay, so others can keep on joining. And in the meantime, we'll do a quick recap. So in the previous class, we had taken up for discussion the topic proportional representation and single transferable vote, right? Then we saw the electoral disputes, Article 71. We also saw the issues pertaining to things like the conditions of service, the oath, salaries, allowances, right? We saw the three funds, CFI, the PAI, and the Contingency Fund of India. We also saw the vacancy in the seat, and under the vacancy, there are various ways in which seats can become vacant, one of which is Article 61, that is impeachment. Beyond that, we saw the powers of the president, starting with Article 74. In fact, that's the most important and the most relevant article, Article 74, which says that the advice of the Prime Minister and the Council of Ministers is binding on the President, which also brought this point to light that the President has no real powers. He or she is largely or almost in every aspect is just a mere nominal head, right? A rubber stamp, so as to say. Then we saw executive powers, and I think that was where we had ended our discussion. Executive powers, the last article we discussed was Article 78, which has two elements. Number one, the duty of the PM to furnish information. And secondly, also with respect to the advice of a single or individual minister not being binding on the president can reconfirm the advice with the entire Council of Ministers, Article 78. Chandana, 42nd Amendment Act is about 1971 or Council of Ministers, both, and lot of other things. So in one single amendment, you can make various changes. For example, let's say you go out of your house to purchase clothes for yourself, right? But when you go out and purchase clothes, say for summer, what do you find a very interesting sale on winter clothes? You purchase clothes for winter also. It's possible, right? Even though you had gone out to purchase clothes for summer, you could purchase clothes for winter also. You can also purchase things for a house. So in one trip to the shopping mall, you can do a lot of things. Similarly, with one amendment, we can make a lot of changes. And the 42nd Amendment Act 1976 was done during emergency, under which a lot of changes were made. So many changes that a lot of people refer to it as a mini constitution. So many changes are made. Yes, in one amendment, many things can. I just gave the example of your house. When you go out on a trip, you can purchase many things for your house, yourself, for neighbors also sometimes, whatever. Same way. In one amendment, various changes can be made. Okay. What else do we have? Sanjay, if the PM does not inform, then it would be not following the ethics and purity of the administration, right? And why would PM not inform? Just informing what is a difficult task in it. So information is okay. Surbi, government employees get their salary from CFI only. As I said, every single penny the government is spending is from CFI only. Every single penny. Jhansi Rani. Jhansi Rani. What is parliament? Parliament is a law-making body in the country which makes laws. Why SLAs are not part of impeachment of president? That is how we have had the procedure, right? SLAs are not made the part of the impeachment of the president because the president is actually, apart from being the head of the entire country, he is largely a part of the parliament where he is signing the bills of the center. That is why states have been given no say in that. It will make the procedure very complicated. Okay. Amendment means what? Changes. Abhiraj, what is CSI and the third fund? Abhiraj, what kind of question is this? CSI, what is CSI? We don't know what is CSI. And what is third fund? Now you have taken 2 classes. We have to revise and choose the correct words. Okay. Budget comes from CFI. Yes, I think I am making all these statements, but attention is not being paid fully and comprehensively, right? Budget comes from CFI only. Every single penny the government spends comes from CFI only. Okay. Let's now, Shelja, such an innocent question. Sir, President gave the order to hang the culprit. Who will hang the president? Why do you want to hang the president? What has he or she done wrong? And president does not give anybody an order to hang. President has no right to punish anyone. Let me be very clear. Who told you this idea that president can punish anyone? No, no. Judiciary punishes, not the president. Okay? President has a power to forgive somebody, not punish somebody. Okay, let's begin our discussion now on financial powers. So what are these financial powers? Again, I don't want to tell this again and again. These are not the powers of the president. These are powers of the government. Article 74. Are we clear? So, there are certain bills in the parliament which are called money bills. What is the meaning of money bill? What is definition of money bill? We'll discuss in detail in the chapter parliament. So for then, please hold your horses and emotions. Don't worry. But just for now, understand that money bills are brought, the proposals like these are brought or introduced in the parliament with the prior permission of the president. Okay? Point number 1. Point number 2, we saw yesterday only. This is Article 267. Article 267, Clause 1. She can make advances out of the contingency fund of India to meet any unforeseen expenditure. We saw it yesterday. And number 3, she constitutes a finance commission after every 5 years. So in our country, there is a constitutional body called Finance Commission. This is under Article 280. Details later on. This body is formed every 5 years to give recommendations on devolving taxes to states and allocating taxes amongst the states. The president forms the finance commission after every 5 years. All these powers are not the powers of the president, they are actually the powers of the prime minister. But we say so, right? It's just a matter of a statement being made. Okay. Then military powers. So you know very well, and if you don't, then now you have this information. There is something called Article 53 Clause 2. Article not important, but she is the Supreme Commander of Defense Force of India. Of course, this is also to be regulated by law. Okay, but the president is the Supreme Commander of the Defense Force of the country. Now, don't think that the president can declare war and all. No, no, no. It's the power of the prime minister. But the president is given this status that you are the boss of the country. So you are the Supreme Commander of the Defense Forces of the country. Then judicial powers. Again, we have this power which is called judicial power, where the president officially appoints the Supreme Court and the High Court judges in the country. So it's the president who appoints the Supreme Court judges and the High Court judges. The Chief Justice, the Supreme Court judge, the Chief Justice of High Court, the High Court judges, all these people are appointed by the President of India. Now, we know very well there is a system called collegium system to appoint the judges. But what is that system under Article 124 Clause 2? We'll discuss it later on when we study judiciary. But as of now, officially, the president appoints the judges of Supreme Court and also High Courts. Very important. The governors don't appoint High Court judges. The president appoints the High Court judge. Okay. Then we have clemency power. What is clemency? Clemency refers to mercy, showing mercy. Mercy powers. Article 72. So what exactly is this clemency power? See, in our country, we have various kinds of clemency powers, but this concept of clemency or showing mercy is a very old concept. I mean, back in ancient Rome also, they had this concept called aedia. So a very interesting concept in ancient Rome was there. This concept of aedia, which was in Rome, it basically meant that if anybody was punished by the authorities there, that person could get the sign of 6,000 people, citizens, and he could be pardoned. The punishment could be removed, right? That was a concept in ancient Rome. It is of no concern to us. So please don't go crazy here. Sir, what is this? What was the procedure like? Who 6,000 people? Ignore it. I just given an example to establish a context. Now, clemency powers in our country for the president are mentioned under Article 72. Similar kind of powers are with governor also. Minor differences. It is mentioned under Article 161. Okay. This is for the clemency power of governor. So, first point. This kind of power is basically to forgive a person who has been punished by the judiciary, right? So please understand that this is not some kind of judicial power, frankly. This is just showing mercy. So what happens? Let's say you are punished by the courts. Courts have punished you. You have to undergo the punishment, whether it is a jail sentence or maybe a death sentence, whatever. You can approach the president and say that, sir, ma'am, I accept my guilt. I know I made a mistake. I am very sorry. Please forgive me. And if the president feels, they can forgive you. Understand? They are forgiving you. You are not telling the president that, sir, ma'am, Supreme Court is wrong. You correct their judgment. No, no, no. You have accepted the court's judgment. That is why president is not challenging court's decision. President is just showing mercy based on your behavior or improved behavior. Okay, this is called mercy. There are 5 types of mercies which can be shown depending on the nature of crime. Number 1 is pardon. So in what case will somebody be pardoned? What is pardon? Pardon basically means we remove the punishment, we remove the conviction, and the person is absolved, free. Absolved means freed from all the guilt. So pardon removes both the sentence and the conviction, and the person is free from all the guilt. So if the court has given you any kind of sentence, jail sentence 10 years, death sentence, whatever, you go to president saying, sir, please pardon me, and the president pardons you, you are free to go. Full enjoyment, right? No punishment, no case, everything is closed. So this in short means you are free to go. Absolved of every kind of guilt. Best form of mercy is pardon. Then we have commutation. Now what is commutation? Commutation means changing the character of punishment. Let us say somebody has been given death sentence. What is death sentence? When the court punishes you with death sentence, you have to be hanged by the neck till you die. Okay? Death sentence. If you go to the president and say, sir, please forgive me, the president says, I can't pardon you. You have committed a crime. I can't let you go. You say, sir, okay, reduce my punishment, commute it, change the punishment. So the punishment is changed from death sentence, you can be given jail sentence. Here, the character of your punishment is being changed. From killing you, we are changing the punishment to confining you or keeping you in captivity. Okay. Then remission. What is remission? Remission means we reduce the period of punishment. So let's say somebody has been given life imprisonment. So what is the meaning of life imprisonment? Life imprisonment means till the natural end of your life, not 14 years as they show in movies. Life imprisonment means you will be in jail till the natural end of your life, till you die in jail. Life imprisonment being reduced to say 10 years, this is called remission. So if you ask the president, sir, I have been given life sentence, I have been in jail for 10 years, please show mercy, then he can say, okay, remission, go enjoy. Then respite. So I am sure you must have observed in our country, as soon as any big leader, politician is arrested, suddenly they develop high BP, sugar, diabetes. Otherwise, they are okay, right? Otherwise, they have no problem. But the moment they are in jail, they have some kind of problem. Okay. So, if your health condition is such that you cannot undergo the punishment, then for a small period of time, when your health is not good, we are giving you lenient punishment. Go and sit in the hospital, no problem. I mean, hospital is way better than the jail. Have you ever been to jail, anyone here? Right? No? It's good that you have not. Great. Please don't do such things to go to jail. But the jails are not really nice places to be in, especially the state maintained jails. Central jail still would be pretty decent, but the jails which are under the state government, horrible conditions, right? So I have also not been there, right? So I'm not speaking from experience, just hearing it. Okay. So, and of course, if you are, let's say, injured, if you have some disease in the jail, so we will give you for a small period of time lenient punishment. Let's say you are given the punishment for rigorous imprisonment. Rigorous imprisonment means you are punished not just to sit in the jail, but also perform some jail duty. So in the movies back then, they used to show that all these people in jail, they are breaking stones, building roads, breaking these mountains, etc. Right? So that is called rigorous imprisonment. You just can't come and eat free food there. You have to work also. But let us say that the prisoner there has some disease. He has jaundice, contracts jaundice for 2 months. So for those 2 months, that person will not be given the punishment to work also. He'll simply sit in the jail and just enjoy food, or can be sent to hospital. So awarding a lesser sentence on account of special fact. Example, health. Example, injury, etc. Right? So that is how it is. And lastly is reprieve. Now for reprieve, you have to understand commutation. We know commutation, but please let me give you some example. Let's say somebody here gets a death sentence, sentenced to be killed, death, hanging by the neck, right? And the court says you will be killed, say on 28th of April. This is the date of execution. Execution of death. Let's assume today the court says that you are given death sentence. Okay. This means what? This means that you will be killed on the 28th of April. Now, you file a request, a petition seeking mercy or clemency from the president, right? You will use the Indian Postal Department service to send the letter. You know how fast Indian Postal Department service is, right? It is very much possible that your letter reaches on 29th of April to the president. It is possible. You are already killed, then what's the point? Any which way, even if the letter reaches, say, after 5 days only, and the president gets your letter, receives, say on 20th, let's assume president receives letter on 20th of April. Do you think the president will keep everything aside and look into your task? It's not possible. The president has a lot of tasks to do. You will say, sir, he has no power only, but still, they are busy people, right? Maybe the president is out of the country, right? So we need to, at that point of time, give the president also some time to look into your case. Why should the president show mercy? Makes no sense, right? So what we want is to ensure that the president also should be given adequate time to look into your entire case. What is the story? Why did the court punish you? After all, the court has found you guilty and has given you death sentence. There must be some reason behind it, right? So based on those things only, the president needs some time to decide. Now, in the meantime, if the president takes too much of time, 28th April comes, you are killed in the jail, right? Execution of punishment. So what we do is initially we file for a reprieve. Reprieve means temporary stay order. So now the death sentence, this will not be executed. Okay? Till the president decides. Are we clear? This is what is reprieve. For a temporary period, the punishment will not be given to you. The president can do what? The president can decide in the meantime. That is called reprieve, temporary stay on the execution of the sentence pending the completion of clemency proceedings. These are all done by the president, not by the court. Please don't involve court here. Court is separate. Supreme Court, High Court, they are separate. This is outside the court system. Are we clear? This temporary stay given by president, respite given by president, remission given by president, commutation given by president, and pardon also given by president. I hope now this point is clear. Okay. Now, these are the 5 provisions that are there to reduce punishment of individuals. Okay. And 2 things. Number 1, no time frame is fixed for president to decide. There is no time frame fixed for the president to decide. Number 2, no procedure or criteria mentioned. So what is the criteria that the president follows? Nothing is mentioned. Okay. It depends on this person's personal opinion. That's it. And this can be used for any kind of crime. Let's say you are in a jail for a bank robbery for 6 years. You can ask for remission, right? Let's say you're in the jail for killing somebody for life imprisonment. You can ask for commutation, remission, commutation. Let's say you are in the jail and you have been given death sentence, right? You can ask for pardon or commutation. You have to write a letter to the president's office. So your lawyer will help you out in case this happens to you in future. Don't worry, right? UPSC will not ask you, please write a letter seeking pardon from the president, right? Don't worry, the format is there. You don't need to know the format of the letter. It will be available once you commit a crime, end up in jail, then you'll know the format. If anybody is interested in knowing the format, the best thing is to know it yourself. Anyway, don't know it yourself, let it be. My question to all of you now, a very important question. The question is, why, after all, lower court, high courts, Supreme Court, all these courts have given their verdicts and have found somebody guilty and have given the punishment, then why are we giving this kind of power to the president to show mercy? Are the courts wrong? Of course not. We have certified at this point of time only that this is not challenging court's judgment. So why do we have mercy provisions? What do you think? What are the reasons? Rationale? Logic? Tell me. President can have different view. Court see only from law perspective. Okay. Unduly harsh punishment. New facts. Article 21. Because he is head of the state. Prakash, death sentence not reducing crime. Show authority and privilege. Give second chance. Okay, fair enough. One last hope. Chance to justice. Chance to reform. Very good. Reforming the culprit. Humanity. Okay. Nice, nice. We see a lot of people also focusing on a very important element of reform here. That's very good. Right? Great. Okay. So let me just summarize everything. Rationale or reasons for the power. Reasons behind mercy petition. Number 1, of course, the very first point is everybody has a right to life and liberty. What is life and liberty? Article 21. You have a right to live and, of course, freedom as well. Secondly, there is always a possibility of judicial errors. Yes or no? Can judges go wrong? Yes, they can go wrong. Fallibility of judiciary. Fallibility. Judiciary can go wrong. Of course. Then, sometimes judges become very harsh. So, to also correct, very harsh punishment. Then, of course, sometimes new facts may come to light. Has anyone here seen this movie called The Shawshank Redemption? So there, in that movie, the whole idea was the person was in jail for a crime he had not committed only. And while in jail, he came to know and he came to meet a person who had actually committed the crime. So it is very much possible that you are punished for something, but then new facts come which prove that you are not that guilty or you're not guilty at all. That's possible. Of course, a very important element is the idea of remorse, rehabilitation, redemption, right? Reform. How do I write it? Okay. Scope for reform. All these are rationals, reasons. Okay. Also, one very important element is, see, judiciary has to apply laws. They can't become emotional and all. Law is there, that's it. To give you a simple example, if there is a law in the country, or there used to be a law in the country called Section 377, it is still there. Section 377 actually said that any kind of consensual sexual activity, consensual also with consent also between two adults, any unnatural sexual activity could be punished with punishment of up to 10 years of jail. Meaning what? Meaning homosexuals would be targeted and they could be punished with jail up to 10 years. Now, in this situation, what can we do? Right? We can do nothing. If I am the judge and a case comes in front of me where the police has arrested somebody involved in homosexuality, then I have to apply the law and punish the person because the law says so, right? So I am, as a judge, bound by the law. President is not bound by the law. He can show mercy. So that's also one reason sometimes. Okay. So this is how this rationale is used. Okay. And just to remind you, section 3, it's not article, guys, section. Article is in the constitution only. Please don't use article for other things. Section is in laws. So IPC is a law. Section 377. And now it's still there, but section 377 has been read down now. Now consenting adults is no longer included. Now section 377 says that any kind of unnatural sexual activity involving children or animals is punishable. So pedophilia, bestiality, any kind of such activities with animals is actually punishable now. Okay. Last point is scope for reform, meaning improvement. People can improve, right? So, of course, scope for reform. Anyway, so these are the reasons as to why we have given the president this kind of power. I hope this point is clear. Now, coming to some very important aspects of clemency. Aspect number 1. President's decision is subject to judicial review. If the president decides to show mercy, The mercy should not be shown on extraneous, extra random considerations like political loyalty. That person is a loyal of my favorite party, mercy. That person belongs to my religion, mercy. That person belongs to my caste, mercy. Of course not. Mercy cannot or clemency cannot be shown on such grounds. If it is found that the mercy is shown on such grounds, then the Supreme Court can cancel this also. I hope this point is clear. Okay. Second, and just to point this out, don't ever have this feeling that this is some kind of a personal emotional thing. Justice S.H. Kapadia had mentioned a statement that the mercy petition is not a private or personal act of grace shown by the president. It is to be based on proper evidences and facts, right? We have to ensure that there are conditions which exist where the mercy should be shown, not randomly. Okay, because you have to keep in mind the effect of clemency on the family of victim, society as whole, what precedent it sets in future. If let us say there's a terrorist and then you show mercy and you say, okay, commutation, don't kill him, jail him only. What kind of precedent is it showing on other people, right? If let's say there's somebody who has committed some kind of crime and then you show mercy, okay, let him go, then people may feel, oh, then I may also get mercy and they may be prone to committing the crime. So you have to keep in mind a lot of things. It's not very basic and generic that to directly show mercy. Okay. Second thing, in our country, movies completely corrupt the reality. So, for example, there was a very interesting part. There's a very interesting movie called Jigar. So, for those who don't know, this was the movie in 1990s starring Ajay Devgan and Karishma Kapoor. So, Jigar was basically a remake of a Van Damme movie called Bloodsport. Some shoddy remake, pathetic. But anyway, in this movie, towards the climax, Ajay Devgan and Karishma Kapoor, they are shown seeking mercy from the governor. Okay. So what they do is, both these people, they take a pink rose and they are walking towards the governor's house, Raj Bhavan. That is not how you seek mercy. Okay. You will not be allowed to go to president personally saying, sir, please hear me out. One phone call, video call. I cry very well. I'll cry and convince you. This is not Indian Idol interview. Okay. You cannot make emotional statements. You write your petition, send it to the president. He'll read it. And if he feels the condition is there, based on your crime, etc. record, then mercy is shown. Petitioner cannot insist on oral hearing. You cannot demand that, president, hear me out. Okay. Then clemency powers are independent of judiciary. They are not a part of judicial power, meaning it is not that you are challenging Supreme Court judgment. Please understand, you are not challenging Supreme Court judgment. You have accepted Supreme Court judgment. Okay. And then you are saying that it's okay, I am accepting Supreme Court judgment. But despite this, President, please, can you show mercy? I accept my fault. This is how it is to be used. And lastly, again, this mercy power is also not the president's power. It's a government which decides. The Home Ministry actually decides, and they will advise the president. The president is just a rubber stamp. Don't get too emotional here. The advice of the Council of Ministers is there. So it is the government which is showing mercy, not the president. I hope this point is clear. Okay. So this is with respect to mercy or the clemency power. Is everyone okay now with this? No issue? Okay. Some of you may, okay, one point, somebody says that these 2 points are related. These 2 points are completely opposite. What is, one very important thing that others should know also, everyone, what is the meaning of judicial review? Judicial review means judiciary can review your decision. Judiciary can review the decision. That is called judicial review. Okay. So whatever decision the government takes or the president takes, that can be cross-checked by judiciary. Clemency power is independent of judiciary, meaning it is not some judicial power, because we are not questioning Supreme Court's judgment. It is not that after Supreme Court judgment you go to president challenging it. Like after lower court judgment you go to high court, then high court judgment go to Supreme Court. That's it. It is not some judicial power of the president, because the president cannot punish you. He can only forgive you. So it is not part of judicial power. It is independent of judiciary in that sense. Okay. And yes, there have been hundreds, thousands of cases of showing mercy. Mercy is shown on a regular basis. So don't be surprised. It's very, very common to show mercy. Extremely common to show mercy. Some presidents show mercy on death sentences, others don't. So it is not that we have not had mercies. It is more common than you can think of. Okay. So these are the Apex Court norms. Now, judicial review means judiciary can check your decisions. That is called judicial review. Let us say you make a law, you pass a decision, Supreme Court says no, decision is wrong, it is unconstitutional, cancelled. That's called judicial review. Judiciary reviewing your decisions. Full form of COM. It gives you a minor shock. Council of Ministers. Okay. Does clemency apply to Naxalites, terrorists? Okay, I have seen a lot of you are asking this, that does it apply to these kind of criminals? Yes, everybody. But will it be shown to them? That may not be possible. Something is available. Clemency is available for every person, every kind of crime. But will that be shown to you? That is a secondary question. You can apply for it. It is not that you commit some kind of crime and for that no mercy is there. Whatever crime you have committed, you can always apply for mercy. After all, there is no guarantee, right? There is no guarantee. Mercy can be accepted or rejected. Okay. Coming back to a very important point here. See, there is no time frame fixed for the president to decide on the mercy petitions. This has actually caused a lot of concern in the country. So back in, there was a very popular case actually called Shatrughan Chauhan case of 2014. So what is this case all about? This Shatrughan Chauhan case was a case in 2014 where the petitioner in the court, he found that in the country across various jails, there were 15 prisoners, at least 15 prisoners who were undergoing or waiting for their death sentence, etc., and were waiting for 1 year, 2 years, in some case 11 years, meaning I am given death sentence, right? Oh, not me, somebody else. Why should I take this thing? Somebody is given death sentence. Now, in that case, what happens? He has or she has applied for mercy petition that please show mercy. Change my death sentence to life imprisonment, full-time jail in life, jail for life. The petition or request is sent to the government, president meaning Home Ministry government. It is pending there. 1 day, 10 days, 1 month, 2 months, 1 year, 2 years, 5 years, 10 years. This person is waiting in the jail, hoping that one day the mercy will be accepted. Every day at 3 p.m. when the postman comes in jail to bring letters, he runs to the postman saying, "My letter has come." He says no, and he goes back. Imagine the amount of mental torture and trauma this person is facing for the last 10 years. And the government could not decide in 10 years. But if you think that mercy is not required, cancel it. Kill the person. What is this? After 10 years, you will say, mercy not given, not shown, sorry, rejected. And then you are killing the person. Does it not mean you are punishing the person twice? Does it not mean you are punishing the person with a jail sentence and also life imprisonment? This is nonsense. So this case brought to light a very big problem. Maganlal Barela, Shivu, Jade Swami, and all these, Jabalpur Central Jail, Belgaum Central Jail, various jails, all these prisoners were there waiting for their death sentence, had applied for mercy petition. In some cases, 11 years they were waiting. Come on, 11 years you can decide. This is nonsense. We understand. You can't decide in 2 days, 10 days, 1 month, 2 months. Home Ministry is busy. But it will not take 11 years to decide on this. So in this judgment, 3-judge bench, and the P. Satasim was the Chief Justice at that point of time. The judiciary said that, see, this is utter nonsense. If government is not deciding and taking so much of time, then we are commuting the death sentence. So we only punish you, right? We are only removing the death sentence. Right? So the point is that undue delay and insanity of undue delay. What is the meaning of undue delay? Too much of delay. Excessive delay is undue delay. And insanity of convict. Convict going crazy. Meaning mentally unstable. We do not kill mentally unstable people. They are possible grounds to justify commutation. If the government does not take proper time or does not respond in limited time, then we will show mercy. We have only punished, we will show mercy. This is there. In fact, in this Shatrughan Chauhan case, the 3-judge bench actually showed mercy to all these people. Secondly, Supreme Court also gave some guidelines. Guideline number 2. In fact, this has been used now. To give you a very simple example, this example which is used by Bombay High Court just recently, I mean 2 years back, was this case of Renuka Shinde. Renuka Shinde or Seema Gavit, all these people. So, in fact, Perarivalan, this was done by Bombay High Court. What was the case? The case was that these 2 women were guilty of kidnapping and killing 13 people. More of kidnapping and killing 13 people, 5 of who were children. They were given death sentence. They had applied for mercy petition. For 7 years, 10 months, the mercy petition was pending in the court, with the government. Finally, the Bombay High Court said, are you going to take any decision? If not, we are going to commute the death sentence, meaning these women will now be in jail for life, will not be killed. So see, somebody who killed at least 13 people, of which 5 are children, they have also been shown mercy. The Perarivalan case, where we'll discuss this under Governor chapter separately. This is a case in Tamil Nadu, which was Perarivalan was a 19-year-old kid who had purchased the battery which was used to defuse the bomb, which killed the former Prime Minister of India, Rajiv Gandhi. So Supreme Court showed mercy in the Perarivalan case. So they can show mercy. If you are not showing mercy, we will show mercy. That's the concept. Number 2. Okay. Number 2. No solitary confinement of death row convict. What is death row? Somebody who is awaiting the death sentence. Death row meaning waiting for death sentence execution is called a death row convict. What is solitary confinement? Have you seen in movies that if you misbehave, if the prisoners are fighting, they are sent to a Kal Kothri, some place where they cannot talk to anyone, they are secluded, kept separately. That is called solitary confinement, right? So Supreme Court says any person who has been given death sentence will not be put under solitary confinement. Okay, because any which way you are about to be killed and you have applied for mercy, you are under so much of pressure and mental trauma, right? And then we'll put you separately. You'll die only alone. Imagine our life during COVID. When we were in our house amidst our parents and siblings, with our pets, full internet, etc., we were going crazy. Imagine somebody with no such things and sitting in the jail waiting for death sentence. So of course, then regular mental health evaluation has to be done for every death row convict. So we have to evaluate their mental health. See, the whole point here is that this kind of punishment, it's a punishment only. Death sentence, where there is a delay, it is very dehumanizing for people. And you are actually also guilty of double punishment. Yes or no? Is it not double punishment? After 10 years in jail, you are telling somebody that, sorry, kill him. Mercy, rejected. Okay. Apart from it, there is also this element of mental trauma. There is also this element of dehumanizing effect. Not treating humans in a humane fashion is called dehumanizing, right? So we have to regularly evaluate their mental health also. Then minimum 14 days gap from the last remedy to date of, what is last remedy? Last remedy is mercy petition. So basically, if your mercy petition is rejected and you have to be killed, at least 14 days time must be given before you are killed. Basically, some time should be given to you to come to terms with the punishment, talk to your family, etc. Right? So this was basically a result of Afzal Guru's situation. So I'm sure you are aware, there was this parliamentary attack in 2001. There is a series also on this, though it's very stylized, on Hotstar, Special Ops. But anyway, don't watch the series, it's okay. So Afzal Guru was the mastermind behind the parliamentary attack. And Afzal Guru, of course, was found guilty. He confessed also, and he was given death sentence. He had applied for mercy petition, and his mercy petition was rejected, and he was within 3 or 4 days killed. So his family also came to know of this through news and media that he has been killed. So this is what Supreme Court did not like. Let's see, you are killing somebody, so please at least have that respect and decency to let the family also know, right? That is why 14 days time. This is the same Afzal Guru against whose hanging the protests were happening in JNU, right? The same Afzal Guru. Anyway, JNU, I mean, the protests were happening, they were largely incorrect. They said that this is judicial killing. See, we may agree on this point that we should have given some time to him and then hanged him, but hanging him was wrong. I don't think that was wrong at that point of time, because he had committed the mistake. Whether you are killing people or not in the country is a secondary question, but he deserved punishment. He was guilty, right? And he had confessed to his crimes. What more do you want? Should God come down and say, and then you will believe? And lastly, post-mortem of all the executed convicts must also be done to establish the cause of death. What is this post-mortem of all executed convicts? Post-mortem, reason for of death. How did somebody die? So in our country, we kill people by hanging, right? So how does somebody die when you hang them? So again, the point is that when somebody is hanged, they don't die through choking. Choking is very difficult. It's a very, it's a maybe around a 2-3 minute process. It is very torturous. Asphyxia, it's very torturous. So normally choking is a very torturous process to kill somebody. So the killing in our system is done in such a fashion that when the person falls, right, or due to hanging, then the bone at the back of the neck breaks, snaps, and punctures the vertebral column, and you die immediately, instantly, right? Choking will take 2-3 minutes. It's very torturous. We can't torture people. So we have to basically kill and ensure that the person is killed through puncture of the vertebral column and not cutting off the oxygen supply, etc., because that is very inhuman way of killing, right? Even in other countries, we follow a proper procedure of killing people. If you go to say USA, for example, in USA, there are some states which follow the system of what? They follow system of giving lethal injection. So there also 3 drug combination is given. Firstly, the person is given anesthesia, then anesthesia, and then pancuronium bromide, so you will not feel the pain, and then you are given potassium chloride to kill, right? So we try to kill people with a painless death. As society and government, we can't torture people. State sponsored torture will take us nowhere. That is why. Okay. So these are all the elements of the Shatrughan Chauhan case. Very important. Please remember all these provisions given, which need to be kept in mind. Okay. Now, before we end our discussion, one point that needs to be understood is this factor that too much of delay is happening, right? So we need to improve upon this also, that there should be some kind of time frame. Fixing some kind of time frame is very, very important. Otherwise, what is going to happen is the person will be sitting in the jail, right? Double punishment, mental torture, trauma, dehumanizing, degrading effect on individual. Why should we torture people like this? So there are some suggestions also. Suggestions. Number 1, fix an ideal time frame. Ideal time frame should be fixed. What is, for example, say 6 months. 6 months could be a sufficient time frame. Within 6 months, I believe the government can decide whether they want to show mercy or not. Secondly, sometimes government say that, no, we are too busy. Will Home Ministry do only these things? If you are too busy, let's do one thing. Alternatively, may set up a pardon board. So we can set up, create a separate body only called pardon board. Let's call whatever name we may call them. That body will be given the task to pardon people, right? So now the convicts will not file petition to the president, but they file petition to the pardon board. And this can comprise of maybe retired judges, social activists, etc. So human rights activists, they can be a part of pardon board if you are too busy. And see, clemency power is not something unique to India. Various countries have this clemency power. If you say go to say Canada only, in Canada there is a body called National Parole Board, which is a tribunal. In Malaysia, in the constitution they have a body called pardon board, which advises the king of Malaysia, the Agong, the royal. In UK, The monarch can also do it on the advice of Council of Ministers, just like India. In USA, under their constitution, Article 2, Section 2, they can do it. The president can do it. So various countries have clemency, and so we also have clemency powers, which should be used judiciously, properly, and in a limited format so that it is not misused. But if it is misused, we of course know that the president's decisions are subject to judicial review. Okay, that is all as far as clemency is concerned. Okay. So we were discussing the judiciary and the president. Now, since we are already discussing the topic of mercy and death and penalties, etc., let us just extend this argument to capital punishment. What is meant by capital punishment? So I hope you are all aware. Capital punishment means death sentence. So capital punishment refers to death sentence. So in our country, do we have the provision of capital punishment? Of course we do. India or the Indian legal system does have the provision of death sentence. Before we discuss further, I would request you to answer a question on poll and hear the question out first, just 10 seconds. Question is very simple and straightforward. Two options only, yes or no. Okay. A for yes and B for no. How many of you feel that we should have capital punishment? Please type A. And others who feel there should be no death sentence, please type B. There is nothing in between. Okay. Either you want death sentence or you say no death sentence in the country. There is no right or wrong answer. Just pick anything that you feel. Or don't write. Choose the poll. Okay. Lot of people feel that we should have death sentence. Great, great. Okay. So in our country, India, we give death sentence. Lot of countries worldwide, they have no provision only of death sentence. So there are two types of countries. Countries can be called abolitionists. No death, DS stands for death sentence. I am repeating for everybody, please pay attention. DS stands for death sentence. Okay. There are roughly 142 countries which do not give death sentence. Either they don't have death sentence in their legal system only, 106 of them, or 28 of them, they have not killed anyone in the last 10-15 years, etc. Then there are some other countries which are called retentionists, which have retained death sentence. Death sentence is given. There are 55 such countries. Most of them are Middle Eastern countries, of course. Countries like Pakistan, Bangladesh, China. India is also there. India is also in the great company of all these countries. Yes, some countries are there, like Singapore is there, USA is there. But largely, it is the Middle Eastern countries where we know very well the quality of human rights and human abuse. Anyway, in India, since 1950 or since independence, we have given 750 plus death sentences so far. Around 760, 770 is the figure now. So that's the number of death sentences we have given so far. Okay. If a lot of you are agreeing on death sentence, then there must be some reason behind it. There must be some benefits of it. So let's say advantages or reasons or benefits. Please tell me, write what will be the advantage or reason or benefit of death sentence. Decrease in population. How with killing 700 people we can decrease population? If not death sentence, people will commit more crime, lesson for prisoners. Crime rate will come down, scared to commit mistakes, good lesson. Maintain law and order, create fear, deterrence, decreasing crime, justice, eliminating evil thoughts, setting example, reducing crime, fear in mind. Okay. Basically, largely, you are saying that it will decrease crime rate also, etc. All these things. Great. So first thing that a lot of you have pointed out is that it will have a deterrent effect. Deterrent effect means set an example. Deterrent effect. What is the meaning of deterrent effect? I'm explaining it. Hear me out very clearly. Deterrent, from the word deter, it will deter other people from committing the same crime, setting an example. Okay. One more point that can be given is, of course, some people are non-reformable. Non-reformable people. No scope for reform. Okay. Then also the victim will also ensure that, or it will rather also serve the purpose of expectation of justice for the victim. Expectation of justice. And eventually, it will also bring a sense of closure to the case. When the parties involved are dead, the case is closed for good, right? Okay. Reducing the prison overcrowding. How many people have been killed? 700, 800. Prison population is 5,52,000. Reducing 800 will not be this is not a viable and logical thing. And expenditure, I think India has money to spend, say, 5-10 lakh rupees on these handful of prisoners, right? So we can afford that much. We are not Pakistan. Non-reformable means people who can't be improved or reformed. They are called non-reformable, right? Okay, great. Nice that you have put in these points. Now, all those people who mentioned setting an example, deterrent effect, it will instill fear in the mind of people, crime rate has come down, etc. Tell me something. We all know the case of Nirbhaya, December 2012. Yes or no? In that case, all the people involved except one person who was actually a juvenile, a kid under 18, were given death sentence. One person committed suicide, others were killed, right? Killed by the punishment of the court, death sentence. This means that suddenly the crime rate has come down now. Yes or no? What do you think? Has the crime rate come down because we have killed people? See, say yes only if you have data to prove it. If you're saying yes, I want data and facts, show me data that crime rate has come down. There is no evidence or data to prove that crime rate has come down, or even less gory crimes are being committed. The same kind of heinous crimes are being committed here and there, everywhere. Somebody being burned, somebody being killed. Hyderabad gang rape case 2 years back. Where is that crime rate coming down? Where is the proof? The biggest misconception that people have is that this is going to deter others from committing a crime. It will not. There is no evidence whatsoever. Do you think all these 142 countries are crazy? And we are the most intellectual ones sitting here. These countries have removed that sentence based on established facts that there is no evidence world over to prove that just because we give very harsh punishments, nobody else will commit the same crime. There is no correlation actually. So, issues. Crime rate coming down. No evidence. No evidence at all. Now, I won't also say that crime rate is increasing because reporting is also increasing. There is no relationship between these two things. In fact, what is more important is that we guarantee punishments of people. In our country, the real problem is not severe punishment, it is certain punishment. So, the issue is going to be between severe punishment versus certain punishment. If the courts can guarantee a punishment within a time frame, then people may also feel that, okay, I will be punished. And to also address this point, this kind of punishment is always irreversible, final. And it is not that this is the only kind of punishment. We have life imprisonment also. Some people also said that they will not repeat the same kind of crime. No. If you put somebody in jail for life, they will also not repeat the same kind of crime. That's it. Why do we have to kill somebody? Now, apart from this, one very important element is it amounts to also cruel punishment, state-sponsored killing. Is it not? It's a very medieval concept of, as a kid, we may have this anguish and lack of empathy and understanding, but you have to also understand that this is a very cruel kind of punishment. And this is a very old idea of justice, which we call as a retributive justice, based on vengeance and revenge. I won't quote Gandhiji here, but frankly, that is how it is. This is based on this very kiddish mindset, revenge. Revenge is a very medieval concept, right? We have to look for reform also. It's very important to open the windows for true reform amongst people, right? So it's a very cruel punishment. Apart from it, non-reformable. See, the whole point is, I am just mentioning issues right now. We'll discuss the conclusion also. Don't worry. And everybody is entitled to their personal opinion. There is no need to fight here. It's your personal choice. Don't worry. But at least we should discuss the other side of the argument also, right? We have to keep our minds open to see what is the counter argument, right? So when you are willing to hear the counter argument, then only can we truly understand that we have liberal values. So understanding and hearing the counter argument is very important, patiently. Apart from it, as I said, non-reformable. How do we find that somebody cannot improve? Only if the person is a habitual offender, right? Somebody who is a habitual offender and will never improve. But the point is there some kind of scientific test to prove this, that the person cannot improve? Say, a lot of you sitting here did not study well in your school days, colleges, but now you are very serious to build your career and you are preparing for UPSC. See, you have improved, you have focused now, a lot of you will clear UPSC. So the point is, there is always room for reform. And what reform are we talking about? We all know very well, these are evidences, studies being conducted on these things, that most, just take one crime, sexual crimes. Most sexual crimes are committed by people who know the victim. Perpetrators know the victim. It's either family member or some friend or some relative or some neighbor, right? Some uncle, some cousin. If we are willing to forgive them and they can reform, why can we not extend this to other people in the society? And what about the mitigating circumstances? What is mitigating circumstance? Circumstances affecting life of an individual. We sitting in our house never faced a difficult time in life. We may have very high moral quotient and compass. Oh, this is wrong, that is wrong. Don't hit, don't beat. Imagine life of a kid who grew up in a family of abusive alcoholic father, beating his mother. That's what he saw. Father dies, mother dies, whatever. He runs away from the house, ends up on the street, is begging, stealing, caught, sent to a juvenile justice home, these orphanages, childcare institutions, which are nothing but dens of physical abuse, mental abuse. The kid faces physical abuse, mental torture, comes out at the age of 18, having seen the worst kind of life, and then you expect the kid, that person, to have the same same moral compass as you have? That is wrong. That is utterly nonsense to have the same kind of expectation from those people who have seen a difficult life. Mitigating circumstances of an individual, circumstances surrounding somebody's life are very, very important. And tell me frankly, in how many cases have we seen the rich getting capital punishment? We are all up for capital punishment. Capital punishment comes to only those who don't have capital. That's the harsh reality. In fact, South African constitution had mentioned this point when they were discussing it, the new constitution, 1995 one. They said that, when you are talking about murder trials or cases, there is always this possibility of judiciary failing. Error in the judicial process. How? There are various elements to it. Number one, manner of investigation. Number two, case presented by the prosecutor. How is the police conducting investigations? We know very well the quality of investigations conducted by the Indian police. Or how the lawyers present the case. The financial capacity of the accused. A rich person can hire top-notch lawyers. Are you aware of the top-notch lawyers' fees in Supreme Court, in high courts? It runs into lakhs of rupees per day, per session. Per day when they go to the court to take up your case, whether the case is heard or not, they will charge you 5-10 lakh rupees. Who can afford it? Rich can, poor cannot. Sometimes lawyers get a fees just not to fight against you. I don't want that lawyer to fight against my lawyer. I will pay him some fees that you don't fight against my lawyer. That's it. Nobody can hire you. For that, they are paid 10, 20, 30 lakh rupees. And of course, the personal bias of the judge. Very important. Attitude of an individual. It's extremely important. Let us say a judge is there who has been having some kind of issue or trouble in his married life with his wife. Let's assume that he's a male judge and the wife is torturing him, troubling him, beating him, etc. He is sitting in the court. Suddenly a spouse case comes, a domestic violence case comes, where the wife is found to be beating the husband. Don't you think he is more inclined into giving a judgment in the favor of the husband because of his personal bias? Of course, it is there. And apart from it, most countries have abolished it. In fact, even the Law Commission in its 262nd report had given a suggestion that we should have death sentence only for terrorism, nothing else. That was their suggestion. And in our country, we have a concept of giving death sentence in only rarest of rare cases. There is no definition of this term. The courts decide on an individual basis, right? That the courts decide on an individual basis. The judges decide on whether punishments should be of death sentence or otherwise. And we have seen a marked improvement now. To just give an example, way back in 1967, there used to be a law commission, 35th Law Commission report. And there the Law Commission was okay with death sentences. In 1967, Law Commission agreed on death sentence. They used to give suggestions on what can be a possible way to kill somebody. So they thought that they gave suggestions on things like gas chambers and all, which could be easily used to lessen the pain. But over the years, 50 years down the line, see the change, right? 262nd report, 5-10 years back, change of heart, that now death sentence should be avoided. So we always improve. Law Commission 262nd report. Only for terrorism. Anyway, now apart from this, of course, as I said, the idea should always be reform. Now, herein comes the question of what then is the right step forward. See, these are pros and cons, arguments in favor, arguments against. In UPSC, see, firstly for life, or in reality in your own life, I would always expect you to have a more liberal opinion, and I would prefer you also deep down improve your opinion. Stop that thing of, no, as a kid we know we are very prone to very extreme sides. Once we grow up, we realize that no, extremities never work in real life. So I would prefer that this should be your stand. Slowly understand that there could be hundreds of things going wrong in people's life, challenges, etc. But for the sake of UPSC, we also have to understand the balance. And for others here also who feel no. Okay. What will be the conclusion? See, a very good conclusion if this question is asked in the examination, finding the balance. How to find the balance? First step, and a very logical step has to be, you can simply say, number one, we have to try for reforming the convict. Yes or no? Is that not the first thing that we should try? Reformative justice. That's the first step. To reform the convict, number one, we have to improve the jail conditions. As of now, jails are places where you don't improve. You just learn new things. You go to jail as a very basic criminal. You come out as a legend, learning new tricks of the trade. That's a problem. Jails have to be proper places for reforming people. We can also have counseling sessions, reforming the convict. We can counsel them. Why don't we try reforming the convict first? Including people who have committed extreme sense of crime. See, extreme crimes are always committed by people who have a depraved mindset. There is something wrong with them, mentally wrong with them. Okay, so should we not take them or treat them as mental patients also? But in your answer, please also write a very important element. There is always going to be a situation where some people are beyond any kind of reform, and even in jail, let's say a terrorist in jail could still plan and plot and give advice to others to commit crimes. In such circumstances where you find that a prisoner is beyond reform at all, then death sentence may be considered. This should be your language. Beyond this, if no scope for reform, then I am repeating again, DS stands for death sentence. I had mentioned it here also. Okay? Death sentence may be considered. This can be a very logical answer. You can also add example terrorists, right? Because terrorism can have a problem that even if you're in jail, you can still plot, plan, and relay information, etc. That could be a problem and concern. That is also a reason why the Law Commission in its report had mentioned that terrorists we can kill, others let it be. So this can be a very viable conclusion. Again, I have given you pros, cons, and conclusion. Still, it is left for you to decide your own conclusion. If you want to write a different conclusion, nobody stops you. It is just one of the alternatives. Okay? Okay. Severe punishment versus certain punishment. What is severe and what is certain? Severe punishment is what is called strict punishment. Strict punishment, right? Like death sentence. In Saudi Arabia, they behead the people. The point, as I was trying to make, is it is not how severe the punishment is, but how guaranteed the punishment is. To give you a simple example, think of what happened in the Hyderabad gang rape case, November 2019. These four, I would say accused only because the court did not find them guilty, were killed in a police encounter. And when the police was coming out after killing them, saying that they had tried to escape, the people on the road were clapping and rejoicing that very good police, great. Why? Is it not strange that the society collectively says, come on, great work? I mean, all those people who say that let's kill others, we should tell them you only kill. We should call them that, okay, he has committed a crime, you want a death sentence, please kill him. Let's see then how many agree to kill a person. See, that problem of people celebrating that was because of judiciary. We know the meandering pace of our judicial system in the country. Taking 15 years, rich people, even if they drive a car and kill others, no harm, no foul, right? That's the beauty of money. So then where is this equality? So this is a problem. And largely, the punishments are not certain. That is what is an incentive for people to commit a crime. If the punishments are guaranteed, then the crime rates will drastically reduce, not the severity of punishment, how severe the punishment is. Anyway, okay. So that is all as far as capital punishment is concerned. And let's end our discussion here only. As I said, everybody will have their own personal opinion. You are free to have your personal opinion. Don't worry. In your exam also, you are free to write whatever you feel is appropriate. Okay. Now, let's do one thing. Let's take a break. Before we begin our next topic, we'll come back to the topic precedent. We had deviated a bit to discussing capital punishment. We'll come back to our topic at hand, the president, and we'll continue with the legislative powers of the president. But let's take a break. After the break, we'll discuss the legislative powers of the president, starting with this provision, that is Article 85. Okay? Break, please, guys. And be back at 6:47. Welcome back, guys. After a long break, Anshu will discuss prorogation, then I'll tell you what is the meaning. Don't worry. We have started asking questions in before. We'll discuss that. Pyre DS's death sentence. Yes, Rohan, that's possible. Anshu, legislative and judiciary, first class, we have discussed it. Legislature makes laws. Judiciary, what does it do? Interprets the laws. Okay. Shalu, how do I know what is register of error? Even the Supreme Court does not know. So we don't really know what is register of error. It is very subjective. Lot of things will go into consideration on what is register of error. Okay. Kritika, any famous case easily solved by other ones not solved in 14 years? How? What reason for judiciary? It takes time. It depends on who is the lawyer, how is the evidence, all these things. Delay in judiciary, we'll discuss under judiciary. Shailja, what is cruel punishment? These are English words. Come on. What is cruel punishment? Sending somebody to jail and killing somebody. What do you think is cruel punishment? Killing somebody. Say beheading somebody. Is it a cruel punishment? Of course, it's a cruel punishment. So, some basic understanding of what is a cruel punishment. So, death sentence is a very cruel punishment. You are killing somebody, right? That's it. Pranay, at the beginning only I had said life imprisonment means full life, not 14 years, full life. Somalia, I'm in favor of capital punishment, but as we know, it's an irrevocable punishment, and thanks to our system and the investigating team, the risk of executing innocent person can be eliminated. Okay, so are you still in favor of capital punishment? What else do we have? Encounter does not come under capital punishment, Sanjeev. Encounter is extrajudicial killing actually. No, Shailja, under 18 we cannot hang them. But now with the passage of the or setting up of the judicial juvenile justice board, kids between 16 to 18 can also be treated as adults subject to the judicial juvenile justice board giving a recommendation on the same. Okay. Darshan, this single word I had explained the meaning yesterday also. I believe this question was asked yesterday. Single. It is that at every point of time, the votes are being transferred to the next person. Just one single transfer. The votes are not allocated amongst all the candidates. That's the concept of single. Police have no right to encounter. Come on. Assassination of Bhagat Singh. Why are we invoking Bhagat Singh here? So, the legendary Bhagat Singh, he was given death sentence by the Britishers. Police have no right to encounter. President dissolving Lok Sabha, Harsh will discuss right now, don't worry. Biswajit, in the last class, will discuss his word constitutionalism. Okay. Coming to legislative powers. Sneha, Bilkis Bano case, we'll discuss Bilkis Bano case under governor, because Bilkis Bano case comes under state government's power of remission. We'll discuss that later on. Okay, don't worry. Now, coming back to our president, let's not forget the topic is president. So, the president under Article 85, this is Article 85, can summon or prorogue the parliament. Summon or prorogue the parliament. So, before that, we also need to understand what is this thing called session of parliament. So, we know that the parliament meets 3 times a year. Parliament, remember in Delhi there is this body called parliament, legislature, which makes laws comprising of MPs. So this parliament, it meets thrice a year. When they meet and pass laws, etc., those things are called sessions. Like you have the polity sessions going on. So polity session means all the classes of polity collectively together is a polity session. Then you'll have a, say, history session, geography session, that is called session. So we have 3 sessions in the country. Budget, monsoon and winter. There is no summer session and all. Budget, monsoon, winter. Budget session, the time frame is January to April. Monsoon 2 months, July, August. Winter, November, December. These things are not mentioned in the constitution. Not mentioned in the constitution. Okay. Now, this session of say around 30, 40, 50 days where all the MPs meet in the parliament in Delhi, it comprises of sittings. Every day when the MPs go and meet, that is called sitting. Sitting today, sitting tomorrow, day after tomorrow, all the sittings collectively become session. Okay. So, second thing is sittings in the parliament. What is sitting? Daily activities in the parliament. They are referred to as sittings. Now, when it comes to daily activity, what happens every day or what is the timetable like in the parliament? Let's draw a diagram only to help you understand better. The parliament starts early morning at 11 a.m. Very early morning, because that's when our MPs can wake up. Okay. For the first 1 hour from 11 to 12, there is something called question hour. What is question hour? We'll discuss it when we study the chapter Parliament. Here, MPs will ask questions from the government, the minister sitting there. From 12 to 1 p.m., we have 0 hour. 0 hour is also like question hour. Again, detail later on when we study the chapter Parliament. After 1 p.m., working for 2 hours, our MPs get tired. Okay, they get tired, they want a break. So we have from 1 to 2 p.m. lunch break. Okay. Finally, from after 2, when the MPs come back, from 2 to 6 p.m. is where they have legislative business. Any kind of bill, etc. is discussed here. Let us write the word legislative business. That is discussion or passage of bills. Okay. So this is what happens every day in the parliament, every day. Now, a small point of difference that you should know. In Rajya Sabha, 11 a.m. to 12 is where you have 0 hour, and 12 to 1 p.m. you have question hour. That's it. That's the only difference. Otherwise, this is a structure that we follow. And again, as I have said, please control your emotions. What is 0 hour? What is question hour? We'll discuss in detail when we study the chapter Parliament. As of now, just think of it, as of now, just think of it that 0 hour and question hour are times when the MPs ask questions from the ministers. That's it. As of now, that should be sufficient. Okay. Now, this is what happens on a daily basis. So, think of this also. So, every day when I take this class here, that should be called a polity sitting. And tomorrow, polity sitting, again, polity sitting. So, every day when we take the class, after 8:30, I tell you all guys that let's meet tomorrow. Till then, the class is adjourned. Class is over. Let's meet tomorrow. So since I am managing the class, I will end the class, right? Adjourn the class, and will tell you to meet tomorrow. So the term for it is called adjournment. What is adjournment? Ending a sitting. Every day at 6 p.m., right? The speaker, the chairperson, the Lok Sabha, Rajya Sabha, the head, the presiding officer, they will say, okay guys, I can see you are tired right now, go home, let's come tomorrow. So the date of next meeting is fixed, adjournment, ending the sitting for the day. And who adjourns it? This is done by somebody called presiding officer. Presiding officer meaning the Speaker of Lok Sabha, Chairman of Rajya Sabha. They are both called presiding officers. Okay? Presiding officer means Speaker and the Chairperson. Okay? Now, after this polity class is over, say the last day of the class, whatever date that is, I will tell you that, okay guys, now the class is over. We don't have to meet tomorrow. The management will decide what is the next class. My task is over. I am not telling you come tomorrow. The management here will tell you, the administrative department will tell you what is the next class and when to meet again. So, whenever adjournment is being done with no next date of meeting being fixed. Okay, whenever I will adjourn the class and I will not tell you when to meet next. So every time I'll tell you that, okay, let's meet tomorrow, let's meet on Monday. But finally in the last class, I will not tell you when to meet because my task is over now. So that thing is called adjournment sine die sine die, both pronunciations are correct. Okay, adjournment sine die or sine die. Okay, this is also done by, if I write PO, I'm sure I'll get a lot of questions. What is PO? So I'm writing presiding officer. And this also ends a sitting. The only difference is in adjournment sine die, date of next meeting is not fixed. Okay, so date of next meeting is not fixed. Now I hope you have understood, so let me write a better word for it. Can I now write date of next sitting? Same thing, not fixed. Okay, this is called adjournment sine die. All this is done by the presiding officer. I gave the example of the class. Okay, both the speaker and the chairperson are called presiding officers. Parliament means two houses, right? Lok Sabha is one house where we have MPs. Raj Sabha is the other house where we have MPs. Okay, the head of Lok Sabha is called speaker. Head of Raj Sabha is called chairperson. Okay, both of them are called presiding officers. Like the whole point is that nomenclatures may differ, but the common term is presiding officer. Now, whenever the session starts, budget session starts, 31st of January, every MP sitting in his house, working in his constituency for the betterment of himself, but for the betterment of his people, he's working towards the betterment of his people, he has to come in Delhi and meet, right? So what will he do? Basically, he needs some information. So he has to be told that, come on, the budget session is about to start, please come to Delhi. And then if he's interested, he'll come to Delhi. If he's not interested, he can say, I'm not feeling well, I'm ill, can give some medical certificate and can not attend also. Like in your school and college, it is not mandatory to attend. You can give medical certificate, same thing here. Okay. When the budget, when the sessions start, when the budget session begins, all the MPs have to be officially informed to come. And when the session ends, all the MPs have to be officially told, get lost now, I mean, go back home now. Okay. Starting a session is called summoning a session. Ending a session is called proroguing a session. Summon means what? Start a session. Prorogue means what? End a session. Okay. So summon and prorogue refer to starting a session as well as ending a session, and both these things are done by the president. Of course, it is not his power, Article 74, end of session. So now let me help you with understanding through an example. Example here. So the polity session will start and the BYJU'S administrative department will send you a text. Tomorrow onwards, you have the polity session. They will officially announce the beginning of the polity session. I will come every day and start the sitting, end the sitting, blah, blah, blah. After the sitting is over, last class, because I don't know what your next schedule is, the administration will come and tell that now next schedule is a history class or economics class or whatever class. Okay. So the same way the president will issue the order to begin a session and to end a session. This is called summoning a session. Okay. Now, one more thing. How many sessions will be there in the in 1 year? It is not mentioned in the constitution, but what is mentioned is that we need to have the maximum gap between two sessions can only be 6 months. Maximum gap between two sessions, 6 months. So we cannot have a gap of more than 6 months between two sessions. Okay. This means what? Between budget and monsoon session, when the budget session ends and the monsoon session begins, the gap cannot be more than 6 months. When the monsoon session ends and winter session begins, the gap cannot be more than 6 months. Okay. Maximum gap is only 6 months. And this gap between the sessions, there's a term for it, like a break. So the term for it is recess, break. For example, the parliament session came to an end on the 6th of April. Today is 13th of April, right? Parliament is not functioning. Budget session is over. Monsoon session is about to begin in the month of July. So currently parliament is in recess. Lunch break, school days, we have a break, recess. Okay. All these things are actually mentioned under Article 85 in the Constitution. Okay. Now, you know one thing, that the president can summon, can prorogue the parliament and dissolve the Lok Sabha. So parliament refers to the two houses. Remember the first class, which was day before yesterday only, at the union legislature level, Lok Sabha, Rajya Sabha, revisions are happening, I'm sure. So parliament sessions will take place on the order of the president, and after every 5 years, Lok Sabha as a house gets dissolved. The tenure of Lok Sabha is just 5 years. That is why after every 5 years, we have election. So the president will dissolve the Lok Sabha. Don't take the literal meaning of dissolve, that Lok Sabha dissolve, water is thrown inside and all, please. Right? Because I feel somebody will ask, sir, is it really dissolved in water or what liquid? No. Dissolved means ending it. Right? Dissolve. This refers to the life of the Lok Sabha comes to an end. Life of Lok Sabha ends. We will have not, let's write not new, fresh elections. We will have elections again. Okay. End of 5-year period. New election, new government, new politicians, new harassment, new government and new good governance. That is what will happen after the fresh elections. Are we clear on this? This is what is mentioned under Article 85. But please understand that all these powers are of the Council of Ministers, not the President. As a mark of respect, we have said that the President is issuing all these orders. Okay. Now, moving on to the next aspect, right to address. So, you know very well that if you don't know, of course, it would be difficult for you to know. The President, this address means speak. So, the President has a right to address the Parliament, either house of the Parliament. If today the President feels that, you know, I want to give a speech, at night at 3 p.m. or 3 a.m., the President says that I have seen some YouTube shorts where motivational video and public speaking, I want to give a speech. Okay. And she says, Lok Sabha, come on, all the MPs, come right now, sit down. Then she can call the MPs and can give a speech. Address is to address the houses. Right to address. This is Article 86. Optional. Whenever she feels like it, she can address either house or both houses together. House meaning Lok Sabha, Rajya Sabha. So that is completely optional. If she wants to, she can give a speech. She's feeling very nice about it. She can give a speech. Second thing is mandatory speech. Now, there are certain occasions where giving a speech is mandatory. Like in your class also, in your school days, college days, giving answers, etc. was not mandatory, optional. But on some days, giving the answer was mandatory. Your viva, remember your viva? Where the only answer you had was sorry sir, same viva, right? So that viva, think of it as mandatory. So as far as some cases and some situations are concerned, it is mandatory for the President to give a speech. That is mentioned under Article 87. Mandatory address of both the houses. Here, there is no option. She has to address both the houses assembled together. So both the houses, meaning MP of Lok Sabha, Rajya Sabha, they will come sit together in the Lok Sabha and the President will give a speech. That speech is what is called the President's speech, okay, or President's address. Clear? When will it be done? It has to be done after the commencement of first session after general election. After every Lok Sabha election, I'm repeating it, after every Lok Sabha election, when the MPs come for the first time, then the President will give the speech. That is mandatory. It is not optional. The President cannot say, I am feeling shy, sorry, I can't give the speech right now. No, you have to. After the commence means to begin. Commencement is an English word which means to begin. And also the commencement of the first session of each year. Tell me please, what is the first session of every year? Please write. Okay, great. Budget session is the first session because it takes place in January, last working day of January. So this is basically reference to the budget session. That is why on the first date of the budget session, it is a President who gives a speech. Are we clear? On these two occasions, it is mandatory for the President to give a speech. Otherwise, on any other given day, it is optional for the President to give a speech. Are we clear? These 2 days, mandatory. Otherwise, completely optional. This is what is the right to address. Speak in front of the houses. Okay. Apart from it, the President also has a right to send messages to Parliament, not WhatsApp messages and all, please. This is with respect to any pending bill, etc. The President can ask questions from the Parliament on what is happening. If the President is getting bored, no work to do, you know very well how busy the President is and how important their post is. So if they have no work to do, then they can ask, I mean, not no work, if they want to, then they can ask the parliament to tell them on what is happening in the parliament today, what bills are being discussed, etc. So she can send messages with respect to any pending bills, etc. Basically, you have to inform the president, and whenever the president asks, inform them. No problem. It's her own power. Now, apart from this, there is also an Article 80. Don't go crazy on the article numbers. Towards the end of the chapter, President, I will tell you which article is important. Okay? Don't worry. So, in Rajya Sabha, that is the upper house that we call, the Rajya Sabha has two types of members. Some MPs are elected MPs who take part in the election of president. Some members are nominated. They are not elected, they are nominated. These people are chosen by the president only. Nominated MPs. So the president chooses or nominates 12 members of the Rajya Sabha from amongst people who have special knowledge or practical experience in fields of literature, science, art, social service. Are we clear on this? So this is what is the nominated MPs. These nominated MPs can take part in the impeachment procedure of the president, but will not take part in the election of the president. Okay, so only from these four fields, no other field. These are the four fields which are mentioned in the constitution. Now you may say, sir, then how about Sachin Tendulkar, PT Usha, Mary Kom? Please, that is also, sports is also an art form. Sport is an art, so it comes under art only. Okay, sports is not mentioned separately, acting is not mentioned separately. So Rekha, etc., all these people have been there as members. So this is just an art form. Are we clear? So now I hope you know that there are some people who are nominated by the what? President. Who nominates them? The president. It is a central government. Article 74, not a real power of the president. Okay? Don't feel that the president is choosing random people. Government is choosing them. You know this person? He's a former Chief Justice of India, Justice Gogoi. How many of you know who this lady is? Your art and culture class is not over yet. So basically, she is a Odissi and Bharatanatyam dancer, Sonal Mansingh, Dr. Sonal Mansingh. Clear on this? Okay. So this is with respect to the nominated MPs. Moving on. Now, in our country, all these MPs who are there in the Lok Sabha or Rajya Sabha, they can be disqualified. Like recently, our Mr. Rahul Gandhi was disqualified, right? On certain grounds. On a ground of defamation. He had defamed the Prime Minister or the Modi community. But there are other ways also to defame or to disqualify the what? To disqualify an MP. If you are not a citizen, disqualified. If you have gone crazy, unsound mind, disqualified. If you are undischarged, insolvent, bankrupt, disqualified. There are certain criteria, we'll discuss those in the chapter Parliament. But if any person is disqualified on those grounds, then who decides? The president decides. She decides on questions as to disqualification of members of the parliament. Article 103. Is this her own power? This is also not her own power. This power is exercised on the opinion of the Election Commission, and this opinion is binding. Are we clear? So on the binding advice of the Election Commission, she will decide on questions of disqualification of MPs in the country on certain conditions. Advice of EC is binding. Then, whenever you want to introduce certain types of bills, a very good example would be a bill called money bill. What is money bill? How is it passed? Details later on. But if a bill is called a money bill, then we have to take the president's prior permission to introduce it. Without president's permission, money bills cannot be introduced in the parliament. Okay. Then there is something called joint sitting, not the previous joint sitting. This joint sitting is for president's speech. Okay. This joint sitting is when the president gives a speech in both the houses or to both the houses. Sometimes to pass certain bills, we need a joint sitting of both the houses. Why? When? Later. So the president will summon a joint sitting of both the houses of the parliament to pass bills or proposals. This is Article 108. We'll again discuss this in say 4 or 5 days. We'll come back to this point. Okay. Now, we have been so far seeing the legislative powers of president. But then, as I said in the very beginning of our discussion on the powers of president, that all these criteria or these categorizations, legislative power of president, executive power of president, nothing is mentioned in the constitution. Okay, we are classifying them for our own understanding. The books classify them for the ease of understanding, right? But there is mentioned in the constitution one power of the president, and that is the legislative power of the president. This power is actually mentioned in the constitution. So whenever a question is asked to you in the main examination to explain about legislative powers, you have to explain about this power only, not other powers. Am I clear on this? Everyone, if you are asked in the examination to explain legislative power, it only means this power. Okay. So what is this power? This power is the power to issue something called ordinance. What is ordinance? Firstly, ordinance is mentioned under Article 123, as you can see here. This is Article 123 of the Indian Constitution. A similar kind of power exists for the governor also. Ordinance can be defined as a temporary law-making power. Very weird, right? It's so weirdly worded. Legislative power of president. By president is a part of executive and you are giving him legislative powers. That's a very weird kind of situation. Law-making power of the government, and this is also power of government only, not the president. Article 74. Don't you think it is very weird that the government is given this kind of power to make law? I mean, we know very well that lawmaking is for the legislature. Strangely enough, we have a provision of Article 123 in the Constitution which says that no, government can also make laws, temporary laws. So why? Very logical actually. Think of all the situations where the houses are not in session, recess. When house is not in session, Remember recess? If houses are not in session, then how will we make a law? Because to make a law, we have to get the proposal approved in the Lok Sabha, Rajya Sabha, etc. But House is not there only in the session. We are on a break. All the MPs are in their constituency or wherever they want to go. Now, if the government feels it is very urgent for them to make some law, some emergency is there, right? Some exigency is there, some urgency is there to make a law, then we say, don't worry, make a law right now. That is the purpose of ordinance. She can promulgate. You will say, sir, what is promulgate? Promulgate means to pass, to issue. Bills are passed, ordinances are promulgated. Okay, that's it. Promulgation basically means to pass or to issue. So the president can promulgate ordinances when either house is not in session. Why? Either house is not in session because to pass a law, both houses have to pass it. Even if one house is not there, then what happens? Then the law cannot be made. So we need to have both the houses in the session. If they are not there, then the president can make a temporary law. Okay. Now, since we are referring to this word again and again, temporary, of course, because we cannot give the government permanent lawmaking power, because the permanent lawmaking power lies with the president, lies with the legislature. So what we'll do is, the problem was houses were not in session, they were on a break. So when the houses come back, then we can table the ordinance that we made, the temporary law we made when they were not there, and tell them that, guys, when you were on break, we had passed this law, promulgated this ordinance. Please approve it now. Okay? So this is what is done. It shall be laid before both houses of the parliament, right? Now, you have to table this ordinance in front of both houses within 6 weeks of the houses reassembling. It shall be laid before both houses of parliament and shall cease to operate at the expiry of 6 weeks from the reassembly of the parliament. Meaning, when the parliament reassembles, within 6 weeks, you will have to table the ordinance, get the ordinance approved. If the ordinance is not approved by the parliament, it is cancelled, it is thrown away, thrown in the dustbin. I mean, not literally. Again, somebody asked me, sir, which dustbin, where is it, what color dustbin is? Don't worry, it is thrown away. It is cancelled, it is rejected. Are we clear? That is why the word temporary. Now I hope you understand the meaning of temporary, because this is dependent on the parliament approving it. And once the parliament approves it, it becomes a full-fledged law. So ordinance becomes a law if parliament approves it, and it has to approve within 6 weeks. I hope this point is clear. One more thing, just a reasoning based question. Now, let us say the ordinance, you know very well, can be promulgated when houses are not in session. Okay. Now, when the house is not in session, let us say 31st of July, we have made the ordinance. Okay, let's assume ordinance has been promulgated. Now, the very, or rather, let's take this example slightly differently. Let's say that on the 31st of July, session of the house comes to an end. Session prorogued. What is the meaning of prorogued? Session comes to an end. Meaning what? Now the MPs have gone back home. House is not there. So if now the government wants to make a law, then they have to use the ordinance. So maybe on the very 1st of August, the government makes a law. ordinance is promulgated. House session was over at this point. Ordinance is promulgated. Now what happens? What is the maximum possible gap between two sessions? Maximum gap. What is the maximum gap? 6 months. This means that if the House ended last time on 31st of July, it has to have a session within 6 months. From here, it can only be maximum 6 months. So August, September, October, November, December, January. 31st of January, 6 months over. Now we have 1st of February. Again, we need to have a new session. What do we call that? Session is summoned, right? Now, think of the ordinance that we promulgated here. This ordinance, which was promulgated on 1st of August, it continues till this date. Why? Because the parliament is not there. But as soon as the parliament comes in the session, within 6 weeks, ordinance has to be approved. If not, it is cancelled. So we say that the maximum possible duration for which an ordinance can survive will be how much? 6 months and 6 weeks. Are we clear on this? So, maximum possible duration. We are finding the maximum duration will be 6 months plus 6 weeks. Are we all okay with this? Right? Okay. Yes, of course, the houses can conduct any number of sessions, but I am taking the extreme example of maximum. What can be the maximum duration? Right? That's it. Okay. So this is with respect to ordinance, basic information. I'll explain once more for some people who still have some issue. The time gap between two sessions can only be maximum 6 months. It can be 5 months, 4 months, 3 months, 2 months. Please don't ask me, sir, can it be 24 days? Yes. Can it be 35 days? Yes. Can it be 84 days? Yes. We can keep on counting only. So maximum gap is 6 months. As soon as the House ended, the very next day the government promulgated an ordinance. The president promulgated an ordinance. Now, the maximum gap between the last session and next session can only be 6 months, right? Let us assume that the government said we will have the next session after 6 months. 6 months. This ordinance which was passed here will continue till here. And after the session is conducted, summoned, we have to table the ordinance within 6 weeks, 6 more weeks, 6 months, 6 weeks. Okay, so that is there with respect to the life of an ordinance. Okay. Now some basic information with respect to these ordinances. First up is to understand why is the ordinance passed. Look at this. If at any time, except when both houses are in session, this means what? It is not some kind of a parallel power, meaning if the House is there in session, then the president cannot promulgate the ordinance, right? House must not be in session. The president is satisfied that circumstances exist which render it necessary, making it very urgent, indispensable for him to take immediate action. What kind of immediate action? We don't know. It is not defined anywhere. It can be any immediate action. Maybe it can be some kind of pandemic. During pandemic, we have to make some temporary ordinances. It can be because of the security of the country. We have to make some temporary laws. Security of India, etc. Okay. Now, this concept of ordinance came into picture in the British times. So back in 1861, we had Lord Charles Canning, right, who introduced this concept. 1861, Lord Canning. And if you observe this ordinance, it's a very unique kind of power which is given to government to make temporary laws, right? So normally we know that laws are made by the legislature, but here government is making laws. So there are some very genuine concerns that people raise with respect to ordinance. What are those concerns? Two major concerns. Number one, ordinance always violates the separation of power. Yes or no? Ordinance violates separation of power. Why? Because as per separation of power, the law making task is given to legislature. Here government is making law. Whatever reason, but you are violating separation of power. Second thing, see, when the law is made in the parliament, all the MPs sit and discuss, argue, raise questions, etc. But when the government is making a law, the PM will sit with his ministers in a closed room, no discussion, nobody knows what happened, law is made, ordinance is promulgated. So basically, the very basic democratic norms are not followed. The spirit of parliamentary democracy, where people discuss and then make laws, that is not followed. So, democratic norms are violated. No discussion. That is why. These are two major issues. Despite these issues, we still have ordinances. Of course, we need to. But this actually is beneficial for the government. Government would love to promulgate ordinances. Otherwise, if I bring a bill, I have to discuss and convince all the MPs, reports will be there, media debate will be there, but ordinance, who cares? Nobody cares. That is why Britishers loved ordinances. In fact, till 1947, we saw in our country over 400 ordinances promulgated. In fact, after this, when we realized that we have our own government, just a sec, guys. So, in the Constituent Assembly, people started saying that this ordinance making power is very bad. This is wrong. Why should the government have this power? But despite this, the likes of people like Nehru and Ambedkar, they supported this. They said, see, sometimes it will be required. What if the parliament cannot meet only? What if some war is there? What if some emergency is there? So it is possible that we may not always meet in the parliament. So at that point of time, the government should be given this chance to make a temporary law. So that is why it was called a necessary evil. Evil because it is wrongly giving government the power. But even Ambedkar justified it, logically saying that Yes, it is okay, no problem. This was the necessary evil idea. And Nehru also convinced all the people in the Constituent Assembly when they're making the constitution that don't worry, we will never misuse this power. This power will always be there, safe. Okay? This power will always be safe, very rarely used. So, to show you an example of how rare it was, in the first 12 years, that is after 1950, the Nehru government made 66 ordinances. 66 times a temporary law was made. Ordinance actually means temporary law. Ordinance, temporary law. Ordinance means temporary law. 66 times. The government wanted us to believe that there were 66 situations where there was so much of urgency that they could not even wait for 2-3 months, because every 2-3 months we have a session of the parliament. And just to point this further, till 2014 in our country we have had 668 ordinances. And till 2021 this number has increased to 744. 744 ordinances. 744 times the government said it is very urgent, we can't wait for even 15-20 days, 1 month, 2 months to make a law. So these powers are largely misused only, right? Anyway, now coming to a bigger concern that was seen across the country. Now see, all the ordinances, of course, because either they were approved, became laws, if not approved, got cancelled. But you did try to make an ordinance. That's the whole point, right? So, very interesting point was observed in some states like Bihar. So what happened was, in 1980s, early 1980s, in Bihar, there was this person called D.C. Wadhwa, an economics and history professor. He was doing some research, right? He was doing some research on the land rates and etc. in Bihar. He found a very unique pattern in Bihar. He found that in Bihar, the Bihar government had promulgated or passed or issued between 1967 to 1980, how many ordinances? Not 10, 20, 30, 256 ordinances. 256 ordinances. The government was functioning with ordinance only. Then what's the point of legislature? For everything else, are you waiting for the House session to end or what? That House will end and then I'll bring an ordinance. The idea should be that we should, of course, ascertain the need for it. See, it is necessary because let us say pandemic happened. Now MPs could not meet. They wanted to make a law. How to make a law? Ordinance, temporary law, till they meet. Till we guys meet, temporary law. These things are possible. But do you expect us to believe that over 250 times in Bihar that ordinances were required? Of course not. That is not it. The case became very important because we also found a unique thing happening. 69 ordinances were re-promulgated. What is re-promulgate? Reissue the same ordinance. That is called re-promulgation. Now, let me help you understand what is re-promulgation. See, the concept of ordinance is very simple. Let us just basically assume we have the monsoon session. Let's start with the budget one only. Every year, budget session, monsoon session, and we have the winter session. Currently we are somewhere here. Yes or no? We are here. In between both the sessions, break is there. The government can make ordinance. Yes or no? Ordinance. Okay. Here ordinance is promulgated. Clear? Temporary law is made because houses are not there. We want to make a law, made a law. When the house comes into session in the monsoon session, we should table the ordinance. Yes or no? Within 6 weeks. But I will not table the ordinance. If I don't table the ordinance, what happens to ordinance? It is dead. Do not present in the parliament. If I don't present the ordinance in the parliament, what happens? The ordinance becomes dead. Over. Let it be. Let it be. After the monsoon session ends, what I will do is I will bring the same ordinance again. Again, the winter session starts. I have some time of 6 weeks to table it. I will not table it. Let it lapse. Let it be dead. Again, it is dead. Again, I'll wait for the winter session to end. Again, I'll bring the same ordinance in the budget session, before budget session. Again, 6 weeks, it can continue. Then it is over. Let it be over. No problem. As soon as budget session ends, I'll bring the same ordinance again. So what I am doing is, whenever the houses assemble, I am not taking any effort to table the ordinance and have discussion. I am just waiting for the houses to be over. In between, I am running the country through temporary laws only. Because if I make a proper law, I have to bring a bill, MPs will discuss, they'll question me. But ordinance, who will question me? I will not table the ordinance in the house only. Right? Nobody questions me. Simple. So this is called re-promulgation. Promulgating the same ordinance again and again. Passing the same ordinance again and again. Are we clear on this re-promulgation thing? So, of course, nothing is mentioned in the constitution that you cannot do it, right? And they took the advantage of it. That is why in the DC Vadhva case, the Supreme Court came down heavily upon the Bihar government, scolding it, saying that what kind of nonsense is this? And Supreme Court said, at that point of time, the Chief Justice was Justice P.N. Bhagwati, right? And he said that this power to make ordinances is to meet an extraordinary situation. I am quoting him verbatim actually. The power to make an ordinance is to meet an extraordinary situation, and it should not be made to meet the political ends of an individual. So that was the statement. And Supreme Court said that this is a fraud. See, they did not say it is unconstitutional, because the constitution does not say you cannot bring the same ordinance again. Because our makers did not think that our future politicians will stoop to this low level to bypass the parliamentary discussion completely or the state assembly discussion completely. They had faith in the politicians. But anyway, the DC Vadhva judgment gave the statement that this is a fraud. Re-promulgation is a fraud on the constitution. You have tried to find a loophole and you are using or misusing the loophole again and again, exploiting it, you are committing a fraud. Scolding it. Anyway, that case was over. Now, the point was that in the very same state, Bihar, same state, after 2 years, one more story started. So in 1989, Bihar government promulgated yet another ordinance that is called Bihar Non-Government Sanskrit Schools Taking Over Management Ordinance. Basically, Bihar government there were roughly 429 Sanskrit schools, and those Sanskrit schools were being taken over by the government through an ordinance, temporary law. So what happened? All these teachers who were there in the Sanskrit school, they became what? They became government teachers, right? Very happy, government job, 1990s, government job, great achievement. Now I can claim dowry, etc. And they got married, enjoying life. Just 2 years back, in the DC Vadwa, the Supreme Court had scolded the Bihar government that please don't re-promulgate ordinances. It's a fraud. But Bihar government said, okay, no problem. After 2 years only, in this particular situation, the Bihar government started re-promulgating the same ordinance. Same management of school, again, and all the teachers continue to enjoy the benefit of government teacher. After a couple of years, when the party changed, new party came to power, it said we will not re-promulgate the ordinance. Ordinance lapsed, dead, over, not brought back again. What does it mean? This means all the teachers or all the schools became private schools. All the teachers became private teachers. The teachers went to court saying, sir, government has cheated us. It was telling us that, see, temporary period we are making an ordinance, we'll make a law. And then they have not made a law. Now ordinance is cancelled. It is repealed. It is lapsed. Now what to do? This matter went to Patna High Court. From Patna High Court to this matter is of 1989, which went to the court in 1991. This matter went to the Patna High Court. It then came to the, of course, Supreme Court. 1998, 1999, then again to a larger bench of 7 judges in 2004. The matter which had gone to court in 1991, finally Supreme Court gave a judgment very, very quickly in 2017. This was the same case, mind you. That was the Krishna Kumar Singh case, right? So this case, which started in 1991, the final judgment came in 2017. You can very well understand the speed of delivery of justice in the Supreme Court, right? Very fast, very quick. Just 20-30 years. Amazing. Hats off. Let's not pass too many comments on Supreme Court. Otherwise, contempt of court can be issued. Full respect to Supreme Court. Anyway. So in this particular judgment, Supreme Court finally undid the wrongs that were done in the previous judgments. So in the previous judgment, Supreme Court had not been very clear with respect to misuse of ordinance. And that is why the governments misused it. It's like in the case of Bihar. So in the state, the governor issues ordinances. At the center, president. Power is exactly the same, no difference. Supreme Court reiterated, said the same thing again. Ordinance promulgation is subject to judicial review. When you promulgate an ordinance, Supreme Court can look into what is the need, because eventually you have to prove that circumstances exist which require me to pass the law for right now, immediately. Supreme Court says, prove it. What is this urgency? Why can't you wait? Prove it. Actually, this was said earlier also. earlier in R.C. Cooper case of 1970 as well. So Supreme Court said the same thing, that please understand, you have to give reasons why this need for ordinance. Why could you not wait for 2 months, 1 month, wait for the assembly to come, the parliament to come? Number two. So what had happened was the Bihar government never used to table the ordinance in the house, they would let it lapse. Now Supreme Court has said it is mandatory. When you promulgate the ordinance, you have to table the ordinance in the house. It is mandatory. Okay? It is mandatory constitutional obligation on the government to lay the ordinance before the legislature. You cannot let it lapse. Are we clear? Very, very important. See, we have to understand, Supreme Court has said also, there is a reason for it. There is a reason for it. See, states can make their own ordinances in the state, center for the central level, both have powers. Okay? So, reason is, Supreme Court said that what is a need, what is the validity and urgency, let the parliament decide. Because you made a temporary law when the parliament was not there. Let the MPs decide whether it was actually required or not, or in the state MLAs. Then you also need to table the ordinance because it requires approval. And if the ordinance has to become a law, you have to table it in the parliament. So for all these reasons, you have to table ordinance in parliament, and re-promulgation will not be allowed. Sorry. What is re-promulgation? But you table the ordinance in the parliament, get it passed. So Supreme Court has clarified that please, no re-promulgation. Now, there's a small window of problem that happens. Let us say session starts, say in the month of, say 18th of July and ends on 19th of August. Okay, that's a monsoon session. The government has made an ordinance right now. Ideally, they should table the ordinance as soon as the House comes and meets. But the government will wait for the session to come to an end. On the very last day, right, the government will say ordinance being tabled now. No time to discuss. Either you pass it, the parliament, right, no time, or I have to re-promulgate. So they are finding this loophole. For example, think of this. Let us say that you had to get your report card signed, very poor marks, and your father is going on a leave or going on some outside city tour for 30 days. You wait for your father to leave at the railway station. When he's sitting in the train, then you show him report card. Dad, sign please. Now he cannot beat you. Maximum 1 slap, 2 slaps compared to the thrashing in the house. So you wait for the very last moment and then you table the ordinance. At 5:30 p.m., ordinance has come. 6 p.m., session is going to be over. Finally, last day of session. What's the point? This is what is a possible and probable misuse that may happen. But otherwise, re-promulgations are not allowed. And lastly, if you bring an ordinance and you table the ordinance and the parliament says cancelled, how dare you make this law? Law was stupid. All the actions you have taken, reverse it. The ordinance is cancelled and all the actions you take in the name of the ordinance in that small period will have to be cancelled, will have to be undone. Okay, are we clear on this? This is what is the guideline with respect to ordinances. Okay. Now, just to help you summarize one very important element here. See, as far as ordinances are concerned, it is very, very important to have ordinances. Trust me, without ordinances, it could be challenging because sometimes we need a situation where the government should be allowed to make temporary laws. Now, what can be further safeguards? Safeguard number 1. Firstly, the government is saying or see, when I say government here, it's the president officially, but reality, the government, the prime minister. The government is saying it is very, very urgent to make an ordinance. Very urgent. Fully agreed. No problem. Let's call it urgent only. My point is very simple here. If it is so urgent, then why don't you call a parliamentary sitting immediately? MPs can't come today, right? They can come after 10 days, 14 days. Conduct parliamentary sitting at the earliest. If it is so urgent, then let the MPs come, right, at the earliest. So don't fix a time, at the earliest. Example, 14 days. There will be some exceptional situations, but for that exceptional situation, we can't have the normal situation jeopardized. Yes, maybe you can say, sir, what if there is a pandemic in the country again? Those are exceptions. We understand. We are not fools, right? The point is other circumstances. Then what? How many pandemics have we seen since independence? Only one. What is this craze and obsession for pandemic? So we understand that it can be a situation where the MPs can't meet. Otherwise, they can always come and meet. Number two. See, President should also exercise his discretion. All we are expecting is that the president should at least ask the government that, sir, what is this? You want me to sign an ordinance? No, I will sign it, no problem. Please look into it once. Reconsider. You will say, sir, what is the point of reconsideration? Eventually, the advice is binding only. Reconsidering actually becomes a very big issue in public limelight. What happens is, normally you always see the president approving everything, right? But sometimes if the president, let's say today something happens, the president has sent back a bill or sent back an order of the government, don't you think that will catch the attention of the entire country? Governments don't want this. So if the president can use the power to send back the advice, maybe the government will have to think twice before giving any kind of suggestion on ordinances. So presidents should exercise more discretion. Send back for reconsideration. So these safeguards should be incorporated to ensure that the ordinances are not misused. See, beyond that, ordinances are required. We cannot simply say remove it completely. Yes, you may argue on this point that no, tell me which democracy has it. USA? No. UK? No. Of course, they don't have it. We are a very unique democracy along with our neighbors who have it. But then it is required. Sometimes it may be required. It is just that we have to prevent the misuse of it. Okay? So that is there with respect to the safeguards. Somebody says, what is the use of sending back for reconsideration? I just explained the entire point. Okay, I'll give you an example. In 1990s, the central government, now please don't ask me the meaning of certain terms, just assume them. I'm giving you a live example of what happened earlier. Central government gave advice to the president to impose president's rule in state of UP. Ignore what is president's rule. Just think on the point now. In 1990s, central government told the president, sir, sign this order, president rule. Okay. The president did not sign it. K.R. Narayanan, he sent it back saying, please reconsider. He knew very well that if they send it again, he has to sign it. But he still said reconsider. And the moment president sent the order back for reconsideration, articles got published in the media and the government came under so much of pressure that at that point of time, it dropped the plan only. It did not send the advice back. Media pressure, public pressure, it works on the government. Okay. So that is there with respect to ordinances. And finally, coming to an end, the last power of the president. Now, this is the real power of the president. Okay, veto power. So many jokes have been cracked on the president. No real power, nonsense. Real power. You wanted real power. This is a real power. Veto power. So, what is veto? Veto means the English meaning of veto is to officially refuse to accept or refuse to allow something. It's called veto. That's the English meaning of it. Official power to refuse. That is what is called a veto power. Refuse to allow something. Okay. Now, for veto power, we need to know the basic information. What is that basic information? We have two houses, Lok Sabha, Rajya Sabha. They pass a bill. We know very well. When Lok Sabha and Rajya Sabha pass a bill, right? The bill goes to whom? The bill goes to passage. Pass. Bill goes to president, right? Now, president has a lot of powers here. What can the president do? President can say, oh, nice, amazing, beautiful bill. And president can simply give assent and the bill becomes an act. All okay so far? No problem. There can also be a situation where the president rejects the bill, does not sign the bill. Possible? Rejects bill or rejects or withhold the assent. What is assent? Assent is approval. Okay, approval. So does not sign or rejects, takes the bill, throws it away. Useless bill. Then what happens? The bill becomes dead. Over. Done. Bill will not become an act. This power of president to reject a bill or refusing to sign a bill is called absolute veto. This power is referred to as absolute veto, and this is normally done on the advice of Council of Ministers, not on his own. On Council of Ministers advice. Okay, so I hope you understand this point. Absolute veto is not his own power, it is on the advice of Council of Ministers. But just like in the case of the advice being sent by government, here the parliament passes a bill, the president can say, wait, I don't like this bill. You please reconsider. this bill has some problem, and the president sends back for reconsideration. Sends back for reconsideration. In this situation, what happens? Now, if the parliament passes the bill again with the same majority, if passed again with same majority, this time the president is bound to give assent. Bound to give assent. Okay. So what you can see here is, for a temporary period, the president has suspended the passage of a bill for a temporary period. Okay. This veto power is called suspensive veto. It cannot end the bill. It cannot prevent the passage of the bill. It is just suspending the passage of the bill for a temporary period. That's it. This is called suspensive veto. Lastly, this is the president's independent power. He can simply send it back without anybody's advice. And lastly, what is the biggest power of the president is this. This is what is the complete power of the president. The president can simply take no action. What do you mean by take no action? The bill comes to president. The president is not signing the bill. But is he refusing to sign? He says, no, no, no. I will sign. Right now my hand is paining. Sorry. Give me some time. Or the president says that I'm not feeling well right now. Eyesight problem. Cannot find my specs. Right? Copy is lost. I'm finding it. Has gone to a foreign country. See, the president is not denying the signature, but he's not signing it also. It's like the president has taken the bill, kept in the pocket, and is roaming here and there, doing everything but not signing the bill. This is what is called pocket veto. Here also, the end result is bill becomes dead only. Over. This is what is known as pocket veto, and this is the what? Real power of the president. Suspensive veto, discretion; pocket veto, full discretion. Absolute is on the advice of Council of Ministers. But these two veto powers are the real power of the president. Pocket veto, suspensive veto. That's why I said the veto powers, some of it, are the real powers of the president. I hope this point is clear. The difference between pocket veto and suspensive veto. Okay? Because there is no power, no time frame for the president to sign, so the bill is inactive only, inoperative, because the bill is pending. It will always remain pending, right? So, two things. If I send back the bill asking the parliament, please make changes, and the parliament passes again, then I have to sign it. But if I don't send it back, do nothing, then the parliament can do nothing about it. One more thing, please don't get confused here. two veto powers can't be combined together. So please don't have these ideas that, sir, if we send it back once and then the bill comes again, can we also use suspensive veto? Sorry, you can't. You can only use one veto at a time. Are you clear? Now, one more thing. These veto powers are not mentioned as words in the constitution. Don't find the article for it. In general, this is mentioned under Article 111. But the words veto and all is not mentioned in the constitution. Okay. And this is meant for ordinary bills. What is ordinary bills? Ordinary bills are, again, bills of general nature, nothing in particular. We'll discuss these later on. And just for you to remember right now, in case a bill is a money bill, then the president cannot have suspensive veto. So you just remember this point. And if a bill is a constitutional amendment bill, constitutional amendment bill, then the president has no veto power. If any such bill is there, it is mandatory for the president to give assent. Okay, this was done via 24th Amendment to the Indian Constitution in 1971. So if a bill is a bill which seeks to amend the Constitution, then there is no veto power the president can use. Okay, for money bill, suspensive veto cannot be used. That is what is mentioned in the Constitution. Okay, so if your question is, sir, can we use pocket veto for money bill? Yes, we can. Though, why will they use it? Because the money bill is introduced with his permission only. Why will he not sign it? But he may use pocket veto. Okay. Now, some examples. Example number one. In the year 2006, Dr. Kalam used suspensive veto. There's a bill called Office of Profit. Or in 1980s, Zail Singh, he was the president. He used pocket veto and refused to sign a bill sent by Rajiv Gandhi government. So veto powers have been used here and there, right? And the difference between these two terms, rejecting and taking no action, very simple. See, rejecting a bill. Let's say you send somebody a message expressing your emotions to the person that I really like you, nice DP, all that nonsense. Okay. The person blocks you immediately, right? Or the person says, no, get lost. The person has rejected you, right? But when you send this message that I really love you, etc., and the blue ticks are there, but there is no response, that is take no action. Clear on this difference? So, at any point of time, a message can come that yes, me too, and you can be happy. So pocket veto has a very unique situation because there is no time only mentioned for the president to sign. So till he does not sign, pocket veto. And you cannot force the president into signing it. Okay. Why rejection? See, rejection has to be understood. Sometimes rejections will take place. For example, let us say, let's use green to write. Let's say BJP has passed a bill in the month of April 2024. Yes or no? BJP passes a bill. But when the bill went to the president, in the meantime, the House, the Lok Sabha got dissolved Elections took place in the month of May, and Congress comes to power. Now Congress does not want this bill, they can advise using absolute veto. So this is how it can be used as an example. Are you clear? Okay. So withholding assent or rejecting it, meaning I refuse to sign. So I have said no. As I gave the real life example that you are facing in your life, somebody is saying, no, I don't love you. Please don't message me. You have been blocked. But in the other case of pocket veto, you have been, how do we say, seen zoned, right? So your message is seen, but yet to be responded. That's the difference. Okay. So that is all as far as today's class is concerned. Tomorrow we'll take up for discussion from the very same point. I'll discuss types of veto powers, and we have discussed all this. It is just one qualified veto which the US president has. We'll discuss tomorrow. And of course, the very important point, why do we need the Indian president? Okay, this also needs to be addressed. That's all for me, guys. Tomorrow we have a class. Don't run away. So tomorrow we have a class, and we'll have the class as usual, 5 to 8:30. That's all for me, guys. Jai Hind. And doubts? Karthi, second point of Krishna Kumar Singh. Karthi, second point simply says that whenever you promulgate an ordinance, when the House meets, you have to table the ordinance in the House. That is what the second point says. It is mandatory constitutional obligation that when you promulgate the ordinance, you have to table the ordinance in the House. No question today because we had no questions from this topic. Actually, I have some practice questions after President. We'll discuss tomorrow. No, I cannot create PYQs. If they ask PYQs, we'll have PYQs. And tomorrow we'll be discussing answer writing also, right? So that's their very important element. Reprieve is made first before all other mercy petitions. Yes, Devansh, absolutely correct. One safeguard. Shalu, sitting done after ordinance issue. Shalu, the point is that if the ordinance has been promulgated, then it is urgent only. So what we want is that as soon as possible, within 7 days, 10 days, MPs should come in the parliament and just have 1 day of sitting, discuss the bill and ordinance and pass it or reject it. Maya Vanshi, what is your question, Maya Vanshi? Veto power can be used in ordinances. Veto power is meant for bills. Ordinance is the advice of Council of Ministers. Understand? Ordinance is Council of Minister advice. There the President has no power. Article 74. Veto comes from Parliament, the Lok Sabha, Rajya Sabha. So it's different. Can President remove Supreme Court judge or see? Why am I asking this? They can't remove, actually. Repromulgation is not allowed. Second point, safeguard. Second point of safeguard says that like I said right now, President should send back the ordinance if the President feels that the ordinance is not required right now. So why should the President simply be a rubber stamp? He has this power, right, to send back once. Use that power. Kamal Pal, no time frame is mentioned actually, even in that situation. But if the President takes too much of time, then maybe the Parliament can initiate impeachment because he is deliberately using pocket veto. Repromulgation means promulgating the same ordinance again and again. Shalu, reviews are being done. What's the big harm? Somebody has to go and file a petition for review. Randomly, Supreme Court will not review all these things. Assent means to approve. Rishandandar. Okay. See, if he uses a pocket veto, the bill will not become an act. I think safeguards have now been explained 5-6 times, so it is sufficient. Re-promulgation is only happening because the government says they are not getting adequate time to discuss the bill, because they present the bill towards the end of the session. That is why. Rejection of Bill Bala is the complete discretion of President. Which rejection? This rejection. Rejection of bill by the President is not the power of President. It is the Council of Ministers' advice, right? What kind of question? How can the ordinance on state subjects be promulgated? Makes no sense, absolutely. We are discussing on the central topics. Why will the center promulgate ordinance on state subjects? Sushmit, yes, definitely. Definitely it's a re-promulgation only. But the point is that we need to also understand and address the element of the problem that the government may face when not being able to place the ordinances or table the ordinances in the right time frame. So that is one loophole that they're trying to misuse right now, but we cannot plug that loophole, right? Biswajit, ASRA, ordinary bill, money bill we'll discuss later on. Ignore it. Ordinance can be extended for maximum 6 months, 6 weeks. Biswajit, Article 87 simply says that there are certain occasions where the President has to come in the Parliament and give a speech. 2 occasions which are mentioned there. Number 1, after every election, and number 2, the first session of every year. Transferable vote. Rules and laws, Neelkamal, was already explained. Rules basically refer to the proper implementation of laws in the country. That is what is rules. He can only use one pocket veto for one bill. How can he use it multiple times? I will not be signing it. I will not be rejecting it. It can only be used once. Praveen, it is clearly mentioned that the President cannot use any veto power for constitutional amendment bills. Yes, Yogita, absolutely correct. Confinement, placing somebody in custody. No solution, Devansh, for that. There is absolutely no solution for that. What is the question, Uddhav? If the bill is passed, it is mandatory to sign. Who said it is mandatory for President to sign the bill? There are certain situations. Sometimes it is not mandatory to sign. Yes, rejection of bill has also happened in case of Rajendra Prasad in 1956, 1954-55, wherein there was a bill for PEPSU, Patiala and East Punjab States Union. And for that particular place, we wanted to pass the budget because the particular area was under President's rule. But later on, the President's rule was revoked and hence the bill was rejected. Okay, I believe your questions have largely been addressed, right? And in case some questions remain, feel free to get them resolved through your subject expert. Biswajit, I had actually answered this question which somebody responded to. Can the President use pocket veto in money bill? Yes, he can. Time limit for veto power. There is no time limit. I've been saying this again and again. No time limit for all these things. Nothing is mentioned in the Constitution, right? Yes, Arminu, that's also there. Ujita, 6 months, 6 weeks concept. Look at the figure again. It is very easy to understand. If you feel what the hell is happening, just mug it up. It won't be asked in the examination, frankly. But otherwise, think of this situation that if an ordinance is promulgated just after a session ends, the next session the maximum time gap can be 6 months, right? Maximum time gap. So this ordinance which was promulgated right now can continue for 6 months. After the house comes back or houses come back, 6 more weeks are given to the government to table the ordinance. 6 months, 6 weeks, the ordinance can continue. Maximum. That's it. I hope now it is understood. Absolute veto. Uddhav, absolute veto simply means when a bill is passed by the houses, it comes to president, the president rejects the bill, says I will not sign, right? Refuses to sign the bill. That is called what? That is what is called the absolute veto. It is done on the advice of the Council of Ministers. Absolute veto repeated. I think now largely your concerns have been addressed. Okay, let's meet tomorrow, guys, and we'll take up for discussion the remaining topics, the vice president, the council of ministers, etc. And we'll continue our discussion further. We'll also be discussing about the answer writing. That's all for tomorrow. Till then, that's all for me, guys. Jai Hind.